is a current policy, file JBE, titled Truancy. And we are revising truancy. They're adding in more responsibilities for parents and legal guardians now. When the students are considered truant and have missed work to make up, it is now going to be the parent's responsibility to work alongside the school to get that missed makeup work in after-school detentions or in-house retention programs, intervention programs and other weekend makeup classes. However, the school system and the school deems appropriate with their scheduling, but the parents will be required to get them there to attend those until their missed work is made up. And during that process of making up that work, the parents would have to meet once a month with the school administration to work through any other issues the student is having. So that's that revision, and if you have any questions, and if not, what is the pleasure of the board?
Any comments, Ms. Stoddard?
Yes. How is it set up now? How are the changes that how is it right now, the way it stands?
So right now, under curriculum and under attendance, it lists that if a student is out a certain number of days, they have that same number of days to make up their work. But when we come into a situation with a truant student that may have missed multiple weeks of instruction, they're not able in the regular school day of instructional minutes, they don't have enough days and minutes to be able to make up that work. So this is just putting some of that burden back on the parent to work alongside the school, and the school's going to say, here are the opportunities for your child. You're now required by policy to have your child attend these sessions so we can get their work made up. So it's just adding the parent into the process of getting the student back on track.
What has been the fallout with them, not other than they're behind, but what has been like, because they haven't gotten it done, then what happens then? Have they just not did it? Have they not come to the teachers and finished their work, or was it, how was it?
Well, like I said, we're talking about truant students, so not a student that was just out a week with the flu. So those students, I mean, in the middle and high school level, if you're not getting your work completed, you're not completing the course with a passing grade, you're not receiving credit, so you're falling further behind for graduation. At the elementary level, you know, it's a joint responsibility between the teacher and the student to get work made up, and not just, you know, we're not going to ask a 7-year-old who's truant to be responsible for finishing all their makeup work. That's an effort between the school.
So I guess what I'm asking, so if they didn't get their elementary level, if they did not make that up and the parent was not involved, what was the consequences?
They could have incomplete grades, they could have zeros put in, and then it would become an SBLC decision on if that student needed to be retained, because, you know, at the elementary level, you're going to look at attendance, but that attendance equates to lost instructional time. So with that large amount of absences, you're also going to have a student who hasn't mastered the standards. So sometimes it would result in retention.
But I like the new policy that you put in place.
Thank you.
Thank you.
Any other comments? Okay, motion by Ms. Smith and seconded by Mr. Ford. All vote. Passes. We have a comment request for the next item, number 2, approval of revision of JCDAE cellular telephones and other electronic devices. I believe we have the comment first, or after she presents? Okay.
Okay. So the next is policy JCDAE. This is a revision of our cellular telephones and other electronic devices. With the new law in place, we've incorporated a statement, a couple of paragraphs up at the top, that no student shall possess or have on their person an electronic telecommunication device throughout the instructional day. And we're really going to focus on that term, instructional day. Our goal here in Bossier Schools is that we're going to protect the classroom in the instructional time of the day. We do not want electronic devices to hinder the instructional time. And it lists some specifically, you know, it lists out devices, but then it also says, you know, it shall not be limited to those devices. So other devices as well are included. We want to be able to have our policy that is sensible enough that our schools can maintain it and it's reasonable. Our students have been bringing cell phones to school for probably 10 to 15 years. And so for us to think that we can put a policy in place that is so restrictive in 2024 is just not reasonable. And so we want to work with our families, our students, but our teachers and our principals and make sure that this policy gives our schools an umbrella that they can start with, and then they can develop, based on what their school needs, those proper procedures for electronic devices, and then the consequences in place if a student breaks that. And so that paragraph was added in there. It also states, our Forethought Consulting that advises us also said, we also recommend deletion of any disciplinary measures to be listed from this policy. And so we don't have disciplinary measures listed in here, other than it says, you know, to confiscate the phone on the first time. Any questions or comments?
Mr. Newman?
Thank you, Ms. Poole. First of all, I don't have an updated copy, so when you reference the updated paragraph, I don't have that. And to my fellow board members, I copied you in on an email, and I have also since talked to Mr. Self directly, Ms. Spinney directly, and got some additional things going. So that's why I was curious to see this updated paragraph, because there was a couple things, Mr. Self, we talked about adding something to Ms. Spinney, you know, kind of expanding that. Is that the other electronic devices that you mentioned?
I'm referring to the copy that was sent out to the board and that is listed in board docs.
We don't get committee meetings and...
No, the email that I sent, it had all the attachments. That's what I'm reading from. The email that was sent to the board on Monday.
Okay, so since you and I have talked, that policy is still as is. It has not been expanded to include all others, particularly the ones we talked about with headphones, AirPods, stuff like that.
We're not listing those specifically because this is a K-12 policy, and we are asking our families to bring those devices at the elementary level. But as you and I spoke, we have talked to our middle and high school schools, because it's a K-12 policy. They know that those are not being allowed unless they're needed for instructional purposes during the day. And so, you know, if a high school chooses to say we're not going to allow headphones, AirPods, anything on this campus, that's within the realms of this policy as written. But we're not going to list them specifically. Our K-5 schools ask our parents to send headphones, and they use them as part of their math lesson every day.
Okay, and based on our conversation, we're okay with, and I'm not saying we have to list it specifically, but are we going to include those items at the middle school and high school level? Because they are a problem, like I told my fellow board members, but if y'all are the ones that I'm going to be coming to, so if you are comfortable with this policy and the way that you're going to enforce it and hold people accountable to it, then I am comfortable with it as well. I know I've talked to Mr. Self separately and you, and I'm good with our conversations. I just thought we were going to maybe add some more verbiage or kind of expand the coverage of that, but y'all tell me, because y'all know where I stand on this.
The thing about policy is I think we always want to formulate a policy around law, and that's where we go to. There's a difference between policy and procedure, and I think we have procedures that are in place for middle and high school versus a policy that's references K-12. And so we have the latitude to put in procedures that we will follow, and what I would assume that your conversation with Mr. Self was about was something that would fall more to procedure than necessarily policy.
Possibly, and then we just discussed like items specifically causing issues at the high school level. I mean, you get kids walking around with headphones on their head, they can't hear fire alarms, they can't hear instruction, and then it's disruptive and things like that. So I just want to make sure that this policy, as it's written, will cover headphones, AirPods, and the disruptions that's caused by cell phones, and it will, I think we have another policy actually that's going to help our staff mandate basically being supported by the administration to do what they need to do to uphold the policy, and it's not going to be just, you know, brush it under the table type.
No doubt, and that's a good point, and we'll get to that in just a moment. But yeah, we can list things specifically in procedural things that we do at various campuses, and we've already started that. We'd already started that in the spring. Started notifying principals and where they can notify communities of what was going to be accepted and what not.
Okay,
Yes, ma'am.
thank you.
Right, so the individual school handbooks, the student handbooks that the parents and the students view and sign off on can include more specifics on what's allowed on that campus. Several of our high school and middle school principals I've already spoken to have already included that in their student handbook. No AirPods, no headphones, those are being listed this year based on the individual schools. But because this policy is for all students, we didn't want to list those specifically.
Right, I just wanted to jump in and say that, in our opinion, the electronic telecommunication devices can include the cell phones and headphones.
Yes.
So for procedures, when we do it at the high school level, we can do that without the general policy specifically listing.
Okay, and that was my concern, is just making sure that everybody understood,
Right.
even administrators, that that does include that. Okay, thank you.
And I failed to mention, the first paragraph of that policy talks about our bring your own technology policy that we've had in place for quite some time. And so that will allow educators at their discretion, if they need devices brought out for part of their lesson, only for instructional purposes, not for, we're finished with our lesson, now everybody can get out their phones, for instructional purposes. And we're making it very clear to our administrators too, this policy will only be as good as we're inspecting what we expect in our classrooms. And so it will be, you know, the due diligence of our principals and assistant principals, as well as our teachers, and then with that responsibility of the students to follow those guidelines in the handbooks, and then we'll have consequences in place.
Yes, sir. Mr. Bullard?
Thank you, Madam Chairman. I have no problem with the policy as presented. I have a problem with implementation, and I think Mr. Newman is alluding to the same situation. We are going to leave interpretation, more importantly, enforcement, up to the individual school site, the individual school administrator. In my case, I have students that attend 2 different high schools. So I'm going to have a parent of a child at Airline who's going to talk to her neighbor down the street whose child attends Benton High School. And here we go. 2 different policies, policy interpretations and enforcement. I have no problem with it. But at the same time, I fear we are going to saddle our on-site administrators, our principals, with a tar baby. It's just going to be an absolute problem to try to enforce. Certainly, it'll work out over time, but I fear we're going to have a lot of kickback. So. Again, I'm okay with the policy. In fact, I'll make the motion, we approve it as presented.
I just want to comment to the board that, I know I talked to Mr. Newman and several others when we started hearing rumors of this, and the way the policy is written, the policy is contradictory of itself if you read the full policy. The top paragraph and then the inserted paragraph are conflicts of nature, and I even spoke to some lawmakers about, how could you even let that go? And the issue and the concern that you share, Mr. Bullard, and all of you share here, we share as well for our administrators, because this policy is really 20 years too late to start with. And to try to put toothpaste back in the tube at this juncture in time is extremely difficult, because this is one of what we have counted as about 20 issues that all carry the same brevity and weight for our administrators and our staffs to take on. So, when laws are made and things are put in place at the state level, our legislators, they're done with it. But the enforcement and the implementation falls on the board, on the administrators, and so that's where the rubber meets the road. And so we will, though, as always, we will manage this, and our staff and our students and our community will rise to the challenge like always, and we will adapt and overcome.
I'll second the motion. but
Okay,
I
and
would
bef-
also like to say that I would like for the procedures to be equal across the board per grade level, for it meant to be a district level procedure instead of individuals. I think it does have problems if we have students come here, they've been handed a reprimand, and then at another school, they have not been given that reprimand because it's approved at that school. I understand the difference in elementary, middle, and high school, but I would still like for us to have district procedures to go to each of those grade levels.
Okay, we have a first and a second, and we also have the public comment. At what point does the public comment on this item, Mr. Self, does that need to be now? Before we, before we do the vote on the, okay. We have Mr., is that, Mr. Rowland, did you have a comment before we move on? Okay. We have Mr. Bernard Friday, who's asked to speak to the board on this item, the cell phone policy.
Good evening, Superintendent Rowland, President Bertrand, the Administrative Committee, and all members of the board. Come to you on behalf of Red River United and the teachers and school employees we serve in Bossier Parish. We do understand that this policy, like Superintendent Rowland said, it's hard to get this jack back in the box. But I want to address paragraph 5 on your policy as it reads: if a student's cell phone is seen or heard during the normal school hours of operation, the phone will be confiscated and turned into the appropriate administrator. Now, the concern comes for who's going to do the confiscating. And I've listened to you all talk about procedures, and I strongly advise that you all put somewhere in the procedure at the building level that the teacher is not in the confiscating business due to, the liability of physical altercation, verbal altercations, which leads into loss of instructional time, and also the financial liability and burden while it's in that teacher's possession. So please keep that in mind when we are doing our procedures and practices at the building level. As always, thank you all for hearing me.
Thank you, Mr. Friday. Okay, we have on the floor a first to accept the policy by Mr. Bullard, a second by Ms. Smith. All vote. Okay, passes. Moving on to number 3, approval of revision of policy JD discipline by Ms. Spinney.
Again, this is a revision to our discipline policy. We have added to the 5th paragraph a statement that Mr. Newman alluded to earlier, that administrators are not going to be able to, not be allowed to discourage a teacher who is trying to provide disciplinary measures for breaking policy, nor shall they be retaliated against for recommending discipline measures or sending a referral, asking a student to be removed. All of those will need to be respected and honored by our administrative team, and that has been added to our discipline policy there.
Okay. Any comments on the board?
Make a motion to approve.
Motion to approve by Mr. Bullard, second by Ms. Brotherton. All vote. Passes. Next policy is approval of revision JGCE, child abuse. Ms. Spinning.
Again, this is a revision to our child abuse policy. It's adding to the list of mandatory reporters at the school level our school resource officers. They're being added in the policy listed, and it also lists that SROs don't need to be receiving information from another mandatory reporter. So if there's a mandatory reporter, a teacher, a counselor, then they will directly report to the appropriate agency, whether that's DCFS, local law enforcement, and that our SROs are not to commence or oversee an investigation into the report.
Any comments on the board?
Motion to approve.
Second.
Motion to approve by Mr. Bullard, seconded by Ms. Smith. All vote. Motion passes. Next policy revision, JDD, suspension, and JDE, expulsion, presented by Ms. Spinney.
We put these two together. There's a lot of coinciding information in the two of these for an agenda item together. For the suspension, we've got adding statements. We mentioned it in the last special session of the board in accordance with Act 324 after that second out-of-school suspension that we would consider if there are any behavioral or emotional challenges causing those suspensions. And those steps we mentioned at the last meeting, what we would do as a designee at the school site, whether we need to recommend outside counseling services, meeting with that parent. So that's included in this policy as well, just carrying over from that same act. But then also, it lists in here that after the third out-of-school suspension, that the principal shall recommend expulsion. Not that they may, they can, but they shall. And so that's going to be something pretty large for us to take on. Those three suspensions, if any of those three out-of-school suspensions are related to dress code or tardies, those would not be counted in the three that would be required before expulsion is recommended. So those are the two that are there. And then also in the expulsion, there are various strike-throughs, if you've had a chance to read it, various strike-throughs and additions. The main thing for the expulsion is they were changing the ages. We had some statements in our prior policy with law that went into effect starting at age 16, and the state has now lowered that to age 13. It still has the grades 6 through 12 band in there, but we're recognizing some of our more serious offenses that require a recommendation for expulsion are happening younger and younger, and so broadening the band of the requirements to recommend expulsion goes down to age 13 for some of those, and then so it changed some of the statements to have pre-K through 5th and then 6th through 12th because of those age changes.
Mr. Buckhouse?
Thank you. Ms. Spinney, as we talked earlier, I still see where it says on page 2 of what you had sent out that any student in grades 6 through 12 who is found guilty of being in possession of a firearm, et cetera, shall be expelled, correct?
I'm sorry, I couldn't hear you well.
Okay. On page 2, firearms, knives, and drugs, any student in grades 6 through 12 who is found guilty of being in possession of a firearm, a knife, a blade, et cetera, shall be expelled, correct?
It is what it says.
Okay, I was on page 2 of the other document.
The heading that says expulsion involving firearms.
Right, that's correct. And so then in the suspension policy, that's the other policy connected to this, it has any student in grades pre-kindergarten through 5 after being suspended on 3 occasions for the drugs or weapons offenses during the same school year shall, upon their 4th offense, be expelled from all public schools of the system. So, you know, if we have a pre-K through 5th grade student that brings a dangerous weapon, illegal substance, you know, on the first try, the first offense, the second offense, can a principal recommend expulsion? They can, but this is saying that by the time they get to their 4th one, you're required to.
So, kindergarten through 5th grade can bring a gun to school 3 times if the principal says it's okay, and then the 4th time he's got to be expelled? Or
So our principals,
I'm just going by what it says here.
and these edits were made based on the law that was recently written. And so that's what our consulting firm and our legal counsel says, our policy needs to match the law. And that's what the law requires. Now, our principals pick up the phone and call student services when there's, you know, a knife with a certain blade length, a drug in question, and our student services department is not going to advise, let's give them 3 more tries. We don't put up with weapons on our campuses, as we all know. And so we're following how the law was written, and of course that's the bare minimum. So our schools all have that autonomy to go beyond that.
All right, would you mind item number 5 on page 3 of 8 on that deal in it continues over on to page 4. Would you mind reading that to me, please?
It's what I just read on the other policy. It's just stated again, any student in pre-kindergarten through 5, after being suspended on 3 occasions for committing drugs or weapons offenses during the same school year, shall, upon committing the 4th offense, be expelled from all the public schools of the system until the beginning of the next regular school year, and the student's reinstatement shall be subject to the review and approval of the board.
And this reflects the law that was passed in Baton Rouge, correct?
Yes, sir.
I hadn't read that law yet.
It was a new one.
It'll be Act 337, if you want to go back and read that, Act 337.
Act 337.
Yes, sir.
But you're saying, though, that they can be expelled if they come one time?
Absolutely. So it's our principal's role to recommend alternate placement, recommend expulsion, and then it's our student services department to give that student their due process, and that's when the hearing would take place, and the actual consequence would be determined by the hearing officer. So the principal simply makes recommendations.
So if he or she recommends not to expel him, then it goes to the hearing, and that could be overturned by the hearing officer?
It would only go to the student services department for hearing if the principal recommends expulsion.
The contradiction here is all of our schools are a gun-free zone. And so once you violate that, you violate the law.
And so we're going to recommend.
We're going to take
expulsion.
care of it, yeah, and all of our principals know that.
Okay. It just seems a little, again, there's more contradictory laws.
In that same aspect where it says, on the 4th occasion, they shall be expelled from all public schools of the system. So does that mean on the 4th, they are not allowed to go to BEC as well? I mean, to the alternative school?
Nope.
Is that what that says?
Yeah, they're done.
It's what it says, but we provide for that opportunity to continue an education in an alternative setting.
Okay.
So we're saying stuff, but we're not really saying something on this. It seems a little confused here.
Much of the policies are contradictory.
I stay confused.
There's a little contradiction in the legislative language of expulsion. They've since expanded expulsion. Used to, they just send you home, but now you have to give an alternate placement. So when they say expulsion, that means placement in the alternative school for a period of more than one school.
But it says all public schools.
Right. But that's copying the legislative language.
Keep in mind, our alternative site is a program, it's not a school.
Okay. Okay.
Thank you. Thank you.
All right. Any other comments?
Have we passed that?
Motion to approve.
Okay, we've got a motion by Mr. Bullard, second by Ms. Brotherton. All vote. Motion passes. Next, we have approval of revisions of policies EB, Building and Grounds Management, GAMA, Employee Smoking, Marijuana, Tobacco Use, and JCDAA, Student Smoking, Tobacco, and Marijuana Use, presented by Ms. Spinney.
This one should be quick and clear cut, I promise. So this is simply taking our current smoking and tobacco policies and adding marijuana in any form to all 3 of those policies. So the difference is the building and grounds policy reflects anyone on any of our school board properties. And then we have a policy for employee use of those things on our properties and a policy of student use. So it is addressing the public, the employees, and the students. That now also added to no smoking and no tobacco is no marijuana in any form.
Okay. We have a motion by Ms. Smith, second by Mr. Bullard. Vote. Motion passes. And finally, we have the approval of revisions of policies IDCH, Home Study Program, IDE, Co-Curricular Activities and Extracurricular Activities, and IDFA, Interscholastic Athletics, presented by Ms. Spinney.
Again, this will be the same information, but it is touched on 3 of our different policies. Act 715 was written this spring that states that our home study students in our districted schools will be allowed the opportunity to try out for interscholastic athletics and/or apply for extracurricular activities, clubs, and organizations on all of our campuses. This was originally put in place as a law in 2010. It was reversed or amended in 2013 to reflect that each local LEA could determine if they were going to allow home study students to participate. At that time, Bossier Schools did not. So from 2013 until now, that has not been an option for those in our district, and now by law they will be allowed. So I've been working with Jeremiah Williams, our district athletic director, and I've already met with the high school principals as well concerning athletics, just to discuss what our procedures are going to look like. Those students will be afforded those opportunities, but still be required to meet the same prerequisites to join those clubs or sports, the same tryouts, proof of residence. They will need to provide their own insurance because they're not a registered Bossier School student, so our athletic insurance policy would not apply. So we've got some requirements that would need to be met before that would be considered, and we will get those reviewed by our legal counsel as well but this would go into place on August 1, so we need to get our information to our schools as soon as we can.
Mr. Bullard?
I am very much opposed to this. I'm totally opposed to it. I understand that not only, and Mr. Self may want to comment, it's my understanding while we're talking about athletic issues, that there has been an interpretation this would open up programs such as BPSB to homeschool students. And I just have a real problem. If you are not a student of this system, then our programs and our extracurricular activities are not available. You want to participate? Attend our schools. And I've heard all the Tim Tebow arguments, so, I don't want to listen to that again. But I'm sorry, I probably can count on one hand the times I've voted against something. I will vote against this. Thank you, ma'am.
Yes, sir. Ms. Brotherton?
You're looking at every organization and club you have in a public school. And, I'm totally opposed to this, and I have talked to Ms. Spinney. This is so wrong. I'm like Mr. Bullard, this is wrong. In life we have choices, and a parent has a choice. You can go to public school, you can go to private school, you can go to a charter school, or you can homeschool, and you take those choices and you live with it. Oh, I'm sorry. Well, they don't want to hear me. But, that's just wrong. You're telling us that if little Johnny wants to try out for cheerleading or whatever, or band or anything else, they make the team, then they're going to wear a uniform that has our school on it. They're going to represent our high schools or whatever, middle schools, and they don't even go to school there. And we're going to be responsible for that child. The coach or the club sponsor is going to be responsible for that child. They're not allowed on our campus if they don't go to our school, but we're going to allow them to participate. I'm totally against it. And I understand it's the law, and I understand that it's, we probably don't have a say-so, but I just really feel really strongly against this. That's just my opinion.
Any other comments?
I know that it is the law that is passed, and I know that several of us disagree with that. I think we still have to have a policy about how to deal with that. but again, I think that's one of these district-wide procedural things that need to be carried out amongst all schools as one procedure.
I concur with that, because I think we all have heartburn, if that's one way to put it, with this, when the comments have been made. I understand that as a teacher and a principal, but at the same time, it's the law, so I agree that we need to have some kind of consistency from around our district in how that is implemented. Let's see, we got two. Which one? Mr. Buckhouse?
Thank you very much. I'm not on this committee, but I evidently have a couple things to say, but a lot of these sports now, in football, we have a lot of players, but in basketball and baseball, you're limited to an amount of people. So it would seem like to me that if a young man or a young woman attends your school, they should have a right not to be booted off of a team or not make a team by somebody that doesn't even go to school there. And I agree with Mr. Bullard and Ms. Brotherton, and that kind of scares me too.
It does, I agree. And you think about that those are limited, but I think the law, Mr. Self, in the law, you can't use that whether or not at school. So the law specifically says you can't use that as an exclusion.
Correct, they have to be afforded the same opportunities under the law.
Right. So these are other mandates from the legislature that we are bound by law, but certainly doesn't make sense to a lot of us. And we have concerns with
We are working on procedures and really engage Mr. Rogers about how to manage this, since they are not covered by our board insurance. And
Right.
also do keep in mind, though, and many of you probably know this, that it's a federal law, all ROTC programs within the United States mandate that homeschool students are allowed to participate.
And we do have current homeschool students that come onto our campuses for their ROTC block every day and participate.
Has that been that way for years?
2 years ago.
2 years ago, okay. I don't remember. Ms. Darby?
Do we know if that includes your charter schools? Is it open, or can they go to the charter schools like they can the public schools?
Yes, ma'am.
Mr. Bullard?
Mr. Self, can we table this and allow you to take another look at it before I don't think anybody here wants to violate the laws of this great state. That's not our purpose. Our purpose is we don't agree with the potential ramifications of following the law. And could we better prepare our policy to reflect the comments that have been voiced here this evening? We want to protect our students, our programs. We don't want a regularly enrolled student to be precluded from attending BPSB, which they are always jammed. We don't want a regular student to be not accepted because of a non-student taking that place. That's the type thing that concerns me. Are we under a time limit that we have to act on this?
Well, the issue is that the law goes into effect August 1st. So, yeah, in my opinion, it would be better to have a working policy that tracks the language of the statute. And anytime there's a new statute that comes out, it's going to be up for interpretation exactly what, does it consider programs like BPSB, things of that nature, exactly how you do the process of it. And my personal opinion, it would be best to pass this that tracks the statutory language and then allow our procedures to step into place to protect as much as we can and to what the interpretations that eventually come out of it allow for.
Am I hearing that it is your professional opinion that our procedures can address the concerns that have been voiced and allow us to, on the one hand, comply with the law, but at the same time address the concerns that have been expressed here today?
Well, I never want to tell you exactly what it is, because if we come back and do exactly as you say, we could wind up in a lawsuit, another district could wind up in a lawsuit, and the court would tell us exactly what that statute means. What I would tell you is that we can come up with procedures that would address your concerns to the extent that that is possible.
Well said, Mr. Lawyer. Well said.
Based on council's opinion, I will make a motion.
Motion by Ms. Smith.
One last comment. Security, what's put in place as far as a student that does not attend there? Do they check in?
Yes, ma'am. So if they're coming on campus for a club period, an athletic PE block, or for an activity they need to attend during the school day, they would have to be checked in just like any other student that was coming in late from a doctor's appointment or anything. They would receive a visitor's badge, however the school identifies them. They would also be required to follow our discipline policy, our expectations in the handbook. It does state that if they break those policies, then they can be dismissed from that club or that team.
One last question. Have we had anybody to break, that came from homeschooling, to break any policy?
To the ROTC program, that's the only ones that are currently attending, not to my knowledge, we haven't.
Okay, thank you.
I have had, this last year for Houghton, there were two that asked me why their child homeschool could not be and wanted their child into a couple of the programs at Houghton. So there are parents out there that want this for their child. I mean, it's not like, you know.
Yes, ma'am.
Okay, we have a first by Ms. Smith. We have a second.
Madam Chairman, I'm going to hold my nose and I'm going to second, and I'm going to vote to approve it. But I want it on the record, I am opposed to
Absolutely.
the basic foundation of this policy. But we got to move on. We got too much else to
Absolutely.
do.
Okay, so we've got a first and we've got a conditional second. I'll vote. Yeah. Was that two?
It was 3. Did you vote?
Yes.
Okay, so it's 3 to 1.
All right. Okay, thank you, Ms. Spinney. Tough
I just
policy.
want y'all to know that since I got in this job, I've brought nothing but yucky policies to y'all. And I feel like the legislators are out to get me. But it is our job to bring you policy that matches the law, so. We've got some really interesting ones that'll be coming up soon that might give you the giggles, so look forward to that.
All right, so do I have a motion to adjourn? Just adjourn? Just, okay, do you know?
All right, we're going to enter into building and grounds.
Yes.
We now have 15 minutes to get